Hi, and welcome back. In this module, we are going to talk about something really important for co-parents in North Carolina, the difference between verbal custody agreements and custody orders. When parents first separate, it's very common to make verbal agreements. Maybe you agree on pickup times or how to share holidays, just to keep things simple and avoid conflict. Is very understandable. At first, that can feel much easier. It has less stress, it doesn't cost anything, and it's more flexible. But here's the problem. Verbal agreements don't have any legal protection. If one parent doesn't follow through, there is no way to enforce it. Police cannot step in based on a text or a promise. And new partners, new jobs, or just changing emotions, it can throw everything off. So, this is why many verbal agreements eventually break down. And when they do, the child's the one who gets caught in the middle. I'm going to give you a couple examples. Let's just say the parents agree that one will have the child on the weekends. But if that parent suddenly refuses to return the child without a court order, law enforcement can't do anything. You can call them up and say, my child hasn't been returned. They're not even going to come over there because there's no court order. They're going to say, ma'am, call your lawyer or go to court or something. Or maybe everyone was completely flexible with the holidays and then there's a remarriage involved and now there's new expectations. With nothing in writing, those disagreements can escalate very quickly. In North Carolina, if there's no custody order in place, both parents technically have equal rights. That means either parent could legally keep the child and neither would be violating the law. It creates instability and stress for everyone involved. If you're currently relying on a verbal agreement, there are some steps you can take. First, start by documenting communications about custody. Emails are definitely better than texts, and all of those written things are better than a phone call. Begin drafting a written parenting plan, even if it's informal, so you sort of have a vague idea of what you want. Maybe you guys talk about it. And let's learn about consent orders, which we're going to cover next. Mediation can be a good step, but that's also part of the custody process to get yourself a consent order, which I'm going to talk about. But the takeaway here is this: trust is important, but structure is essential. A clear, written, enforceable plan is not about trying to create conflict between you. It's actually about protecting your child's routine and giving both parents peace of mind. In a perfect world, if I could be in charge of everything, all custody cases would resolve in a consent order, also called a parenting agreement, if it results coming out of the North Carolina Mediation Office, which almost all of our cases do when they agree. What is a consent order? It's a written custody and visitation agreement between parents, not done by ChatGPT, but is done by the parents with a trained mediator and signed by a judge. Once it is signed, it carries the full weight of the law. It's enforceable just like an order issued after a trial, but without the stress of the trial. Think of it this way: you and your co-parent agree on the terms, and then the court backs you up. You should consider filing for a consent order if, for example, you and your co-parent already agree on custody, but you want to go ahead and, put everything in writing. Again, not ChatGPT, you have to do a court order. You've been working off of a verbal agreement and you need more stability. Or let's just say you want a clear schedule for holidays or travel. Let's say there's been inconsistency, or you're worried the other parent won't follow through. Or you just need a court order for things like school, passports, or medical decisions. Remember, North Carolina, without a signed order, both parents have equal rights. That can create serious problems if you disagree. A consent order covers the essentials: physical custody, meaning where your child lives and when; legal custody, meaning who makes decisions about school, health, religion, holiday, vacation schedules, pickup and drop off times and location; rules for communication. Some parents also add travel limits, relocation notice, or even guidelines about introducing new partners. The goal is clarity, so there's less room for conflict later on. Here's the basic process. You file a custody complaint with the court. It's you versus the other parent, even though that looks like it's very confrontational. It's not meant to be. And even if you're not planning to go to trial, you still have to open a case in order for a court binding agreement and signed order to be created. This will automatically, by filing, you're going to automatically alert the mediation office to contact you. You both need to attend an orientation and watch state-approved parenting class videos, and they will walk you through all of that. You will then attend mediation. It will just be the two of you and a trained mediator, nobody else. Assuming that you both agree on all the terms, the mediator will draw up your order. You'll have 30 days to review it and make any changes. And if you're both saying, yes, this is good, then he or she will have it signed by a judge. And then voila, you have a signed custody consent order that is subject to the contempt powers of the court. That was a mouthful. No court, no fuss, no muss. Where are you going to file this? Usually you're going to file in the county where your child has lived for the past 6 months. And if you're not sure about that, just contact your local family court office. They can guide you. If one parent later refuses to follow the consent order, you can file a motion to show cause, or which is also a motion for contempt. The court can enforce the terms, add makeup time, or even change custody if needed. Here's the bottom line. Verbal agreements may feel cooperative, but they don't protect you or your child. A consent order is legally binding, court approved, and enforceable. Having a clear order is not about conflict. It's about preventing conflict and putting your child's best interests first. A consent order gives your agreement legal teeth. It protects your child, protects you. It gives both parents clarity and peace of mind. So you can stay focused on what really matters, your child's future. So you can also download our custody planning tool, which is one of the resources that's available with this course. And just a reminder, once again, even though I'm very delighted you're here and I am a lawyer, I am not your lawyer unless you are a client and we've already signed an agreement. But for the most part, this is just a reminder that everything in here is meant to be educational and empowering, but not to take the place of legal advice to you specifically about your unique circumstances.